This changes the rules. 2 seconds. That's all it took. 2 seconds between a man opening a car door and a fatal gunshot. 2 seconds between a decision and a death. But what came next? That's what really shook the system. While the media was busy chasing political drama and courtroom celebrity cases, a quiet but history-making event was unfolding inside the highest court in the land. In a stunning 9-0 decision, the U.S. Supreme Court didn't just tweak an old rule, it dismantled a long-standing legal standard that has shaped police encounters for decades. The case is called Barnes versus Felix, and on the surface, it's about a traffic stop gone wrong. But beneath that headline is something far bigger, a total rewrite of how we decide what counts as excessive force. For years, courts looked at only one thing: what the officer felt in the exact moment they fired. If they claimed they feared for their life, that was often the end of the case. Not anymore. The court made it clear. Real justice means looking at the entire encounter. What did the officer know before? What did the citizen do or not do? Could the situation have been de-escalated long before the trigger was pulled? The old split-second standard is out. A deeper, more contextual judgment is now required. And here's why this matters to you. If you carry or even plan to carry, the way you're treated during a stop, a search, or a confrontation could now play out under this new lens. This isn't just a win for one man's family, it's a major shift for every American who believes in both their rights and their responsibilities. In this episode of Survival Firearms, here's what we're breaking down: what the justices actually ruled and why it shocked the legal world. Why this decision is a game changer for self-defense and concealed carry. Real-world cases that led to this moment, and what they teach us. How you can stay legally safe under this new legal standard. Welcome to Survival Firearms, where we don't just react to the headlines, we help you understand what they mean for your freedom, your safety, and your rights. Let's unpack this decision and what it means for every armed citizen in 2025. Chapter 1. The story of Barnes versus Felix. At the center of the case is a tragic and fast-moving confrontation. An officer, Robert Felix Jr., conducted a traffic stop on a man named Ashton Barnes, who was suspected of toll violations. Things escalated quickly. The officer asked Barnes to exit the vehicle. Barnes opened the door and initially complied, but then, in a sudden move, attempted to drive away. Officer Felix, acting instinctively, jumped onto the vehicle's door ledge. Within 2 seconds, he fired 2 shots into the car. Barnes was hit and fatally wounded. The entire event from vehicle movement to fatal shot lasted around 5 seconds. In the aftermath, Barnes's mother sued Officer Felix, arguing that her son's Fourth Amendment rights had been violated by the use of excessive force. The question was this: did Officer Felix act lawfully in that instant of perceived threat? And more importantly, what legal standard should courts use to decide that? Chapter 2. The Old Rule and Why It Failed. Why did the moment of threat doctrine take hold? Because use of force encounters often turn on fast decisions. Courts were reluctant to second-guess split-second judgments with perfect hindsight, so they narrowed the analysis to what the officer reasonably perceived at the final moment. The problem was never the desire to avoid hindsight bias. The problem was the blindness that followed. By ignoring what came before, the law sometimes gave a pass to avoidable danger. If an officer's earlier choices cornered both people into a deadly bind, poor positioning, failure to wait for backup, commands that were unclear or contradictory, those choices disappeared from the legal equation. The snapshot could look justified even when the movie showed it never had to happen that way. This is why Families and Civil Liberties advocates pointed to case after case where a person who posed no real threat wound up dead after a chain of misunderstandings. Stephon Clark, Sacramento. A vandalism call. A backyard. A phone mistaken for a gun. Whether lights, distance, or tactics could have changed that outcome was often treated as irrelevant under the old rule. Oscar Grant, Oakland's Fruitvale Station, New Year's Day 2009. Not a shooting by a patrol officer during an active stop in the classic sense, but a transit police use of force that raised enduring questions about training, escalation, and accountability. Grant was shot while prone on a platform. The officer claimed he meant to deploy a taser. The case became a symbol in California of how seconds can define a lifetime. Sean Monterosa, Vallejo, The decision to fire through a windshield from a moving vehicle magnified scrutiny of pre-shot choices. Under a narrow moment test, only the final perceived reach mattered. Under a totality test, tactics and risk creation can be weighed too. Courts needed a standard that filtered out pure hindsight, but still allowed cause and effect to count. That is what the Supreme Court just restored. Chapter 3. The Supreme Court's Rejection of Narrow Analysis. In a 9-0 decision, written by Justice Elena Kagan, the court rejected the moment of threat doctrine. Instead, the justices ruled that excessive force cases under the Fourth Amendment must be evaluated based on the totality of circumstances. That means the entire interaction is relevant. Officers' decisions leading up to the use of force matter, and courts must weigh whether the force used was objectively reasonable from the perspective of a reasonable officer at the scene, not in hindsight. The opinion emphasized the totality of the circumstances inquiry has no time limit. Earlier facts may show why an officer would view ambiguous conduct as threatening or as harmless. In short, context matters. This sets a new precedent for how excessive force is evaluated, and that affects every interaction between police and citizens nationwide. Chapter 4. The New Standard. Totality of the Circumstances. The Barnes opinion does not invent a brand new doctrine. It revives the classic Fourth Amendment inquiry, objective reasonableness in light of all the facts known to a reasonable officer, considering the totality of the circumstances. The court makes 3 pivotal clarifications that now govern use of force analysis nationwide. 1. No artificial time limit. The inquiry may include earlier conduct that helps explain the endgame. Prior commands, positioning, radio information, the suspect's compliance or confusion, the presence of bystanders, and the availability of safer alternatives can matter. Courts are not limited to the last blink. 2. No perfect hindsight. Judges cannot micromanage tactical choices with the luxury of slow motion. The test remains what a reasonable officer on the scene would have perceived and done, given the information available at the time. 3. Causation counts both ways. If prior choices by an officer unreasonably created the danger that led to force, that is relevant. If prior conduct by the suspect reasonably signaled lethal risk, that is relevant too. The scale must weigh everything. Justice Kagan writes that earlier facts may show why ambiguous conduct looked threatening or harmless. That sentence is the beating heart of the opinion. It recognizes that lawful behavior by citizens, especially those carrying legally, can be misread in a fraction of a second, and that courts must account for the lawfulness of those actions in judging the officer's response. Justice Kavanaugh's concurrence, joined by Justices Thomas, Barrett, and Alito, underscores the flip side. Traffic stops are dangerous. Flight can turn lethal for officers and the public. Courts must continue to guard against unrealistic expectations. The point of the concurrence is not to narrow the rule, but to remind everyone that reasonableness remains the touchstone. Take those together, and you get a balanced command to the lower courts. Look wide, think fair, judge in the real world. Chapter 5. The Totality of Circumstances. A New Legal Framework. The Supreme Court didn't just reject a narrow doctrine, it gave us something better. By emphasizing the totality of circumstances, the court created a clearer, more balanced framework for evaluating police use of force. This means that both sides of the story, what the officer saw and what actually happened, must be weighed together. Here's what's now required. Courts must examine the full timeline of events, not just the final moments. Officers can no longer claim justification based solely on perceived threat if that threat was shaped by earlier decisions they made. Prior interactions, behavior patterns, verbal cues, and escalation attempts all become legally relevant evidence. That changes everything in how self-defense cases, wrongful shootings, and lawful gun owner encounters will be litigated. It's a standard rooted in fairness, and it restores constitutional depth to how the Fourth Amendment is applied in modern law enforcement scenarios. Chapter 6. Why this matters to gun owners. Now the connection that your audience cares about most. In the last decade, more routine police-citizen encounters have involved lawful firearms, concealed carry disclosures during traffic stops, open carry in states that allow it, home checks related to red flag petitions, and investigations where a citizen is both the reporter and the armed defender. Many tragedies began with a lawful movement that looked threatening to an officer keyed for danger. Under a narrow moment of threat rule, the person's lawful status and prior compliance could be erased by the final instant. Under the totality rule, those facts must be considered. Picture this scenario in a state that requires disclosure. You are pulled over at dusk. You inform the officer you are licensed and currently carrying at the 3 o'clock position. You move to produce your permit as instructed. The officer, amped by a prior high-risk stop, misreads your movement as a draw. A shot is fired. Under the old test, courts might have asked only whether the officer reasonably feared a gun was being drawn at that instant. Under the new test, the court must consider what you said, what you were told to do, what the officer knew, and whether his approach contributed to a misread. That is not a loophole for criminals. It is a lifeline for law-abiding citizens who do everything right and still wind up in a deadly misunderstanding. Real cases illuminate the stakes. In Phoenix, Arizona, 2016, Daniel Shaver, not a firearms case in the carry sense, but a pure lesson in commands, confusion, and escalation, was shot in a hotel hallway while trying to follow a complex orders. The public reaction focused on how instructions and posture can create or diffuse perceived threat. Under Barnes, the totality of those commands and the suspect's efforts are squarely relevant. In California, the Kelly Thomas case in Fullerton, 2011, was not a shooting. It was a fatal beating of an unarmed, mentally ill man. It nonetheless became a landmark in how pre-force decisions and escalation can lead to a death. Though the legal posture differed, Barnes's totality rule embraces that logic for Fourth Amendment seizures involving force. In Cleveland, Tamir Rice, a realistic toy gun, a 2-second arrival. Courts once focused on that last flicker. Totality requires asking whether the approach and information sharing made that outcome far more likely than necessary. For carry communities, the practical takeaways are concrete. Say it early, say it clearly. If your state requires you to inform, do it before you move. Officer, I am licensed and currently carrying on my right hip. My hands are visible. How would you like me to proceed? Ask for instructions and repeat them back. Do you want my permit? I will reach slowly with my left hand into my wallet now. Clear feedback loops reduce misreads and create a record that courts can weigh. Slow is smooth, smooth is safe. Move deliberately. Keep hands high and visible whenever possible. Narrate your actions. Know your state's script. Some states require immediate disclosure, others do not. Know the rule so you're not improvising under stress. Barnes does not guarantee safety. It guarantees fairness in the courtroom afterward by forcing judges to look at the whole encounter. That can save families from losing everything to a misunderstanding, and it can save officers from unfair second-guessing when the total picture shows they acted reasonably. Chapter 7. Second Amendment Crossroads. Carry rights meet Fourth Amendment protections. The overlap between the Second and Fourth Amendments has never been sharper. Every year, thousands of gun owners are involved in police encounters, from routine traffic stops to high-tension emergency calls. In many states, you are legally required to disclose that you are armed. The very act of disclosure can set off a chain of reactions. Old rule risk. If the encounter ended in a mistaken shooting, courts looked only at the final perceived movement. New rule advantage. Now, the officer's awareness of your lawful carry status, your compliance with disclosure laws, and the clarity of commands will all be considered. Scenario example. In North Carolina, a man is stopped for speeding. He informs the officer, I have a concealed carry permit and I'm armed at my right hip. The officer, distracted by radio chatter about a nearby armed robbery, misinterprets the man's reach for his license as a threat and fires. Under Barnes, the court must consider the driver's clear verbal disclosure, the officer's prior knowledge from dispatch, whether the officer gave explicit instructions on how to retrieve documents, the driver's compliance with state law. This does not automatically make the shooting unlawful, but it prevents the lawful disclosure from being erased in court. For red flag law enforcement, this ruling also changes the calculus. Officers serving gun seizure orders must now anticipate that pre-force planning, including time of day, method of approach, and communication, will be scrutinized. Sloppy or aggressive execution that triggers unnecessary escalation will no longer be invisible in court. Chapter 8. What this means going forward. The road ahead is significant. Already, legal scholars are calling Barnes versus Felix the Miranda, ruling for use of force cases a decision that fundamentally changes how the Constitution protects you during encounters with the state. What's next? Police training will need to adapt. Officers must now account for how their actions before a shooting may be judged in court. Gun rights advocates have a new legal tool for defending citizens wrongfully targeted in gray area encounters. States and municipalities may face new lawsuits, policy revisions, and pressure to align law enforcement practices with this broader interpretation. And the court didn't stop there. By issuing a 9-0 ruling, they sent a message: this isn't political, this is constitutional. It may be the beginning of a new era in how police powers are restrained, rights are enforced, and citizens are respected under the law. Chapter 9. Repercussions for state and federal courts. This wasn't just a slap on the wrist for the Fifth Circuit, it was a direct challenge to how multiple federal circuits have been handling excessive force cases for decades. Some circuits had adopted versions of the moment of threat rule. Others applied broader standards inconsistently. Now, with this unanimous Supreme Court ruling, all courts are on notice. Here's what will happen. Lower courts must now reevaluate pending excessive force cases. Appeals from previous rulings under narrow standards may be revived. Future cases will lean heavily on the Barnes versus Felix ruling as precedent. In plain terms, this case is reshaping federal jurisprudence across all 50 states. Lawyers representing victims of police overreach now have a Supreme Court-approved argument. Context is constitutionally required. That gives new legal life to cases once deemed unwinnable. Chapter 10. What to do now? Practical takeaways for citizens and officers. If you are a gun owner, disclose early and clearly if required by law. Narrate your actions. I am moving my left hand to my wallet. Avoid sudden movements. Keep hands visible unless instructed otherwise. Know your state's legal requirements cold. If you are in law enforcement, think about how your choices in the first minute will look in court. Give clear, unambiguous commands. Avoid overlapping orders with partners. Use lighting, positioning, and time to your advantage. Why this ruling hits home. The Barnes versus Felix decision isn't just another footnote in legal history, it's a course correction, a signal that our rights as Americans aren't snapshots to be frozen and judged in isolation. They're living protections meant to be understood in full context, especially when life and death decisions happen in seconds. If you carry, if you train, if you believe in accountability on both sides of the badge, this ruling matters because it means the law now has to look deeper. Not just at how an event ended, but how it started, what led to the threat, and whether it could have been avoided altogether. From California to Texas to Ohio, this precedent reaches across state lines. It doesn't just reshape how cases are judged, it reshapes how people think, act, and prepare. At Survival Firearms, we don't just talk guns, we talk truth. And truth is your best defense, whether you're in a courtroom or on your front porch. So here's what you can do next. Share this video with your friends, family, or your local carry group. People need to know this decision exists. Leave a comment. Does this ruling give you peace of mind or raise new questions? I want to hear your take. Subscribe to Survival Firearms so you never miss the updates that could define your rights in the real world. Stay sharp, stay legal, stay free. And I'll see you in the next one, right here on Survival Firearms.